Welcome, friends, to day 5 of the National Constitution Center's review of the first time in history that the Supreme Court has broadcast its oral arguments live. I am Jeffrey Rosen, the president of the National Constitution Center, and we've been beginning these meaningful sessions in public education by reciting together the National Constitution Center's inspiring mission, which comes from the US Congress. So here we go. The National Constitution Center is the only institution in America chartered by Congress to disseminate information about the Constitution on a nonpartisan basis in order to increase awareness and understanding of the Constitution among the American people. And that's just what we're trying to do in collaboration with C-SPAN, as we've invited you to join us in listening to these important oral arguments and then convening afterward with some of America's most thoughtful scholars who have filed briefs and are taking positions on both sides of the case to help us unpack the arguments we just heard. Friends, this has been an extraordinary morning. We've heard 3 cases involving the president's power to resist subpoenas. In the first cases from Congress, and in the second case from a state district attorney. And joining us to understand what we just heard are 2 great scholars and 2 of America's leading experts on the law of the presidency, especially as it relates to subpoenas. Andrew Grewal is professor of law and Joseph F. Rosenfield Fellow in Law at Iowa Law, where he focuses on tax law, administrative law, statutory interpretation, and constitutional law. His article, Congressional Subpoenas in Court, was recently published in the North Carolina Law Review, where you can check it out. And he's also the author of the forthcoming article, The President's Tax Returns, which will soon be published in the George Mason Law Review. And Gillian Metzger joined a brief of separation of law scholars in support of respondents. She is Harlan Fiske Stone Professor of Constitutional Law at Columbia Law School, where she also serves as faculty director of Columbia Law Center's for Constitutional Governance. She's a leading scholar of constitutional and administrative law and author of administrative law cases and comments. Andrew, Gillian, thank you so much for joining.
Thank you.
Well, we have a remarkable morning to recap. And let's begin with the first 2 cases, which had to do with subpoenas issued by Congress. And we'll talk about them for a bit, and then we'll turn to the second case involving a subpoena from the New York District Attorney. The very first question, Andrew Grewal, that Chief Justice Roberts asked was, it sounds at the end of the day, this is just another case where the courts are balancing the competing interests on either side. And yet the president's lawyer emphasized that the restraints of the powers of Congress are emphasized in this case because it's a separation of powers disputes. Please help us understand, Andrew Grewal, how the president sees this case as differently than an ordinary case involving a congressional subpoena, and what legal standard he thinks that Congress should have to meet before it can subpoena records from the president.
Yeah, I suppose at a very broad level, this is a dispute like any other. That is, one side is arguing one thing and another side is arguing another. The strange thing here for a court is that usually when a court is thinking about whether Congress has done something, a court usually gives deference to Congress in upholding a statute, for example. A court also provides deference to the executive branch in determining whether, for example, a regulation that the executive branch has issued is valid. What's weird here is that when you have 2 branches colliding, you're not sure what to do. Congress gets special deference for its subpoenas, but at the same time, various precedents tend to protect the president with respect to his exercise of functions. So the president is pressing very hard on this idea that I'm the president. I'm not like some random person that Congress subpoenas. You need to apply a heightened standard to a subpoena that comes to me, as opposed to Congress, which is saying, we are Congress, you are supposed to defer to us. It's dangerous for you, a court, to second guess our stated purposes. broadly speaking, Congress is saying that if we have a legitimate legislative purpose for a subpoena, the court should uphold its validity.
Thanks so much for that. Gillian, as Andy says, the ordinary standard for a subpoena is quite deferential. Is the subpoena asking for information that's relevant to a legitimate investigation? That came from a case called R Enterprises. It was mentioned at the end of the last case, and that's been the central standard that people have to apply. Here, the president's lawyers are arguing for a heightened standard. They cite the Nixon case, and they said that the question should have to be, is there a demonstrated need or a critical need for this information? Several of the justices, including Justices Ginsburg and Sotomayor, said that just flies in the face of history. Congress has asked for information from the president all the time. There's a long history, said Justice Sotomayor, a long, long history of Congress seeking records and getting them. And we've said in the past that a congressional subpoena is valid as long as there's a conceivable legislative purpose and the subpoena is relevant to that purpose. So Gillian Metzger, help us understand the difference between the president's standard and Congress's standard. Is it the difference between a critical need or a demonstrated need versus a legitimate need? And how would it play out in practice in this case?
Well, yeah, so I think Andy said it nicely in that ordinarily when you're talking about a legislative subpoena, the tests have been pretty deferential in an area that Congress could, pertinent to an area that Congress could legislate in, for example. That's not a very high standard at all. And of course, the problem is here you're talking about the presidency. On the other hand, the standard that the Department of Justice and the president are arguing for come from cases in which the president has articulated a claim of executive privilege, which has been acknowledged as a reason why you heighten the showing. What the president and DOJ are asking for here is that shouldn't just be the standard for when you acknowledge a heightened reason for a showing. It should be just the basic standard across the board whenever you're talking about the presidency. And so that's a difference. They're really trying to pull the presidency out and making what was previously the standard in cases of privilege to now be just the baseline for anything against the president.
Thanks very much for that. Andy, is that, you both laid out the two standards closely. Is it correct that the court would have to change its law if it said that the president has to, that Congress has to meet a higher standard when it's asking for information that the president hasn't asserted a special executive privilege over? And as Justice Kavanaugh said, how would it play out in this case? He asked the president's lawyer on your argument that the Nixon demonstrated specific need standard should apply, or the demonstrably critical need standard. Explain how it would play out in practice, like a case like this. If you could tell us how it would play out and whether or not Congress could meet the standard, that would be great.
Yeah, so in terms of the heightened standard, I suppose the president is arguing that there is a heightened standard, although that argument is traced to the Constitution itself. That is, we use a phrase, legitimate legislative purposes to define the scope of the Congress's authority to subpoena. And Congress can surely write lots of laws on lots of different things, tax laws, immigration laws, labor laws, everything under the sun. If you look at the US Code, it's going to be volume after volume. Nobody could read them all in a lifetime, at least not without going insane. But with respect to the president, the authority of Congress to pass legislation is hotly disputed. And this kept popping up during the oral arguments. The president is saying, yeah, Congress, you can pass laws if you want. There's lots of things you can pass laws on, but not about me. You cannot pass a conflict of interest statute that says I have to recuse myself, because if the president recuses himself, then what's left? He's the executive branch. So yes, it is the same standard, a legitimate legislative purpose, but the president is arguing that Congress, you can only potentially regulate me, legislate with respect to me in a very narrow way. So it's the same standard applied to a very special circumstance from the president's perspective. Now, with respect to the subpoenas at issue, the president is arguing, well, you want all my financial information? For what purpose? You want to force me to disclose my finances? Well, it's one thing if Congress passes a statute creating the Treasury Department or the State Department, and those departments are the baby of Congress. Congress makes them. Congress can pass statutes saying that if you are the Secretary of Transportation, you cannot own stock in auto companies. The president here is saying, well, the people through the Constitution created my office. I am not your baby. You can't regulate me in the same way. So the president is trying to fight hard against the idea that these subpoenas relate to valid legislation. He's asking, well, if you are going to collect all my financial information, to what end does this serve? This does not relate to some valid legislation. And given the narrowness of your authority over me, these subpoenas aren't valid in the same way that they might be valid with respect to other federal officers who might have a business interest worldwide.
That's helpful. So now as I am understanding the case, it may be helpful to put on the table a case called McGrain versus Daugherty, which came up a couple times. This arose in 1927 in the middle of the Teapot Dome scandal. And it was a challenge to a contempt conviction for Mr. Daugherty, whose brother was the former Attorney General and hadn't prosecuted wrongdoers in the Teapot Dome scandal. And Congress wanted Daugherty to testify, and he didn't want to. And the question was the Senate committee out of bounds in issuing this contempt order, since the purpose of the investigation had nothing to do with the committee's legislative purpose? And the court upheld the conviction, saying that in order to be valid, we have a presumption that congressional investigations have a legitimate legislative purpose, but you can't issue subpoenas in order to investigate in ways that have nothing to do with legislation. So Gillian, is that a central part in the case? And then to help us understand how that led to objections like Justice Ginsburg, who said one must investigate before legislating. The purpose of an investigation is to frame the legislation, and we can't have courts deciding in advance what Congress is allowed to potentially legislate on and what isn't, because that would raise separation of powers concerns.
Yeah, so just at the outset, just to say, I mean, the claim of presidential immunity from congressional regulation, that's a pretty strong unitary executive claim. I think it's one that, against it, people would cite necessary and proper clause and other things. I just want to put on the table, that's a very aggressive, in my view, claim of the presidency, and we do have financial disclosure and other requirements that apply to the presidency. So just to put out there that in of itself is not necessarily not a somewhat aggressive claim. And as Andy mentioned, it's very much a contention in the case. I think that one of the things that is interesting to me and struck me about the argument was how you did have Justice Ginsburg, and I think you had some of the more liberal justices emphasizing Congress's need for information. But there was much more focus on the potential burdens on the presidency and much less concern with what Congress needs in order to perform a legislation in an intelligible way, which is information. The themes in the past, if you look at the court's prior precedent, I think it's quite interesting. First of all, there hasn't been a whole lot, and that's because these things tend to get negotiated out. One of the things that's happening is that we're having very strong resistance to the kind of negotiations and oversight relationships that have previously existed between Congress and the executive branch. So these are coming in a more stark form. But we haven't had that many cases, and the cases that we've had have tended, when you're talking about Congress's investigatory power, to be very deferential to Congress and to acknowledge that Congress needs to investigate in order to legislate. And I would also say, I think it's important to recognize Congress has an important oversight function over the executive branch. Congress needs to perform that oversight in order to legislate, but legislating doesn't have to be the primary focus of that. It's part of our separation of power system that we rely on Congress to do that. And that really didn't get mentioned in this case, probably because the subpoenas here are dealing with personal private documents of the president before he was president, but nonetheless goes to this idea of Congress has some real needs to be able to subpoena to investigate and then figure out whether or not legislation is needed and not have to identify the legislation from the get-go.
Many thanks for all that. This question of where the congressional subpoena comes from is one that Justice Thomas raised in his very first question. He said, I'm very interested. Do you think there are any implied powers for the Congress to subpoena private documents? answer. I think there might be limited powers to subpoena private documents. What would you mean by that limited power, said Justice Thomas? And the answer was usually forward-looking, aggregated information, not going backward to assemble a precise history. And then Justice Thomas finally said the DC Circuit opinion, there was a dissenting opinion by Judge Rao who said the information should be requested under the impeachment power and not as a legislative subpoena. So Andy Grewal, what is the answer to Justice Thomas's question? Where in the Constitution does Congress's subpoena come from? And going back to first principles, what are its limits? Did you hear most of the justices agreeing that the limits are that the subpoena power has to be to in the service of investigation, in the service of possible legislation rather than investigation? Or was there some appetite on the court for imposing further limits on Congress's power to subpoena when the president was involved?
Well, if you look at the Constitution, you'll find Congress's subpoena power in the same place that you find the president's executive privilege authority. That is, it's nowhere written on the page anywhere. These are implied. We say that, well, if we are going to create a legislature with the legislative power, well, of course, a legislature needs to collect information to do its work. And so we imply that. Now, it is certainly the case, and I think this gets to the Mazars case in particular, that Congress has lots of different powers prescribed in Article 1 of the Constitution. It's not just the legislative power. So if it's invoking the legislative power, then the test is, well, is there some potential legislation out there that it could pass to support it arresting someone or issuing a subpoena? But Congress can do other things, such as impeach a federal officer. In those circumstances, the question isn't, well, we're thinking about impeaching so-and-so. The question isn't, well, can we pass legislation with respect to so-and-so? Is the information related to our impeachment function? So a source of contention in these cases is that the president is arguing these committees aren't trying to pass legislation with respect to me. What they're really trying to do is find out if I broke the law. They should be exercising their impeachment power, which conceivably could be the case. However, the relevant committees don't have the authority to pursue impeachment in these circumstances. So the president is saying, this isn't about legislation. You want to know whether I broke the law, which is a suitable subject for impeachment, but the entire House has not authorized you to conduct an impeachment investigation. Therefore, you are going outside of the bounds of your authority. So broadly speaking, these investigative authorities are implied in the Constitution, and they can take on different forms based on the particular function being served. And that threshold inquiry makes a big difference in the validity of a subpoena.
Thank you for that. Gillian, so if the power to subpoena is implied from Congress's general power to legislate, tell us about what you heard from the oral argument about what its limits are. Chief Justice Roberts asked a question that clearly concerned him, as well as Justice Alito and some of the other justices. Is there a subject on which legislation, if the principle is that Congress can subpoena for any subject on which legislation can be had, said Chief Justice Roberts, can you give me an example of subjects beyond what Congress can legislate? And the respondents hesitated to put anything out of bounds, and at the very end there was some question about whether subpoenaing the president's family's medical records just to embarrass him might be relevant or not. But what did you hear in Chief Justice Roberts' question? And tell us about both sides' answer to that question of whether there are any subjects beyond which Congress can legislate for which subpoenas cannot be issued.
Yeah, so I was actually struck by, I think actually across the court, there was a desire for limiting principles. It was a question that came up in different guises, but there was some concern about how would we protect against harassment, some sort of recognition of the potential for harassment there. Where I think the differences may lie in whether or not you try for a categorical bar. So for example, this idea you can't legislate on the president. So that's a kind of a categorical bar. Anything about legislating on the president would then be barred. or you go for a more case-by-case situation. I thought there was a very interesting question towards the end by Justice Kagan, where she was trying to distinguish between the different subpoenas in the case. And the one from the Financial Services Committee that sort of used President Trump as a case study. Hard to know why the president would be your most logical case study, versus those that were from the Government Oversight Committee or the Intelligence Committee that were trying to find out more about financial disclosure and conflict of interest, and more relevant in that sense, specifically to why you'd be asking the president. So that might be one way to like sort of try and have some identification of the tying of the scope and the topics of the subpoenas to what to why you're asking the president. I did myself, I got a sense that there was some interest across the court in some kind of limit, not necessarily a categorical one, but one that would limit the sort of generally very broad power of Congress wherein the president is involved. And that line between the different kinds of subpoenas might be one that some justices are drawn to. I think some others want a more searching scrutiny that would have more of a kind of showing of categorical of kind of the specific need, the higher critical need standard that we heard in both the cases coming up in various times.
Thanks for that. Andy, what did you hear in the questions of the justices on that point? Who seemed interested in a heightened need or special needs standard? Who was interested in distinguishing among the different kinds of subpoenas? And since you've written an article on congressional subpoenas, where do you believe the Constitution draws the line?
Yeah, I think the general line is easily stated. That is, with respect to legislative subpoenas, we have to figure out on what may legislation be had. I was skeptical, or am skeptical, of this case study analysis. That is, as Gillian nicely pointed out, there's some set of subpoenas that relate to potential ethics legislation. Congress is interested in the president's finances because they want to know, maybe we should change our financial disclosure laws. That's one set of subpoenas. Another one relates to an entirely appropriate subject. That is a wrongdoing or potential fraud in the banking industry. And I think everybody should agree that's something that's appropriate for Congress to legislate on. In fact, that's what I would like for them to legislate on. But the stated reason for asking for not just President Trump's information, but even his grandchildren, every check written on their behalf, is that they needed a case study with respect to this issue. And the advocate pointed out a nice argument. If Congress can surely pass food safety legislation, but does that mean they can demand a log of everything that President Trump eats? Diet Cokes and cheeseburgers, apparently, but can they get even more granular? Now, that illustrates a limit on the investigative authority. That is, though Congress can pass legislation, one of the limits is that they can't expose individuals' private affairs solely for the sake of exposure. They cannot substitute investigation for legislation, and so on. So I think the second set of subpoenas nicely illustrates the limits that Congress can legislate, but it can't trample on private rights.
Thank you for that. It can legislate, but it can't trample on private rights, and that would involve issuing subpoenas for the pure purpose of harassment and not to legislate on matters for which it's competent is the standard that I hear you are articulating, and that was a version of what the president's lawyers were articulating as well. Gillian, tell us about the relevance of the Nixon tapes case and the Watergate cases. Both Justice Breyer and Justice Ginsburg focus on this. Justice Breyer said to the government's lawyer, "Are you saying that Sam Erwin's subpoena done under legislative power at the time of Watergate was unlawful? Yes or no?" And the lawyer said that was okay, but it didn't involve impeachment. And Breyer said, no, this wasn't impeachment. And then he said, as for Justice Ginsburg's questions, I'd like to know, in Watergate, the court gave contested material involving the very workings of the presidential office to the prosecutor. Why is it that whatever standards applies to personal papers, why isn't that a weaker standard rather than a stronger one? Tell us about what Justice Breyer was getting at and what you think it suggested about his view of the case.
Right. Well, I mean, so one of the interesting things about these subpoenas is precisely that they were not going after public records or conversations between that the president might have had with top aides, as was at issue in Watergate. There were also claims of privilege in some other cases, one that came up in the second case, the Inree Seal case, and some others. So in those instances, the court has recognized that the executive branch has a need for some confidentiality in order to function. And so you have a strong kind of constitutionally based interest. In this case, what you're talking about are subpoenas that are going for private information that is not privileged. It is in third-party hands. There's never been a claim of privilege made against it. It isn't even attorney-client privileged. It's also the case that when you're making a claim of executive privilege, it's incumbent on the executive branch to make that claim, to pass that initial threshold, and then you do the assessment, and the burden switches to Congress to justify why it needs it. And so in this case, when you have private, subpoenas trying to get private information, so what I think Breyer is getting at it is, in part, those aren't the kinds of contexts in which we usually think there should be a claim of some kind of special privilege just because you're the president. And I think the argument that was made against that is, well, there's this concern about harassment and the potential for harassment that is specific to the president. And that could be, if you start really investigating legislative purpose to get at that, though, then you have the problem of courts really second guessing congressional purpose and stated purpose, which the court in this long range of cases upholding legislative subpoenas has been reluctant to do. I think it's also interesting that, there really is, if you look at this in terms of historical practice, which is something that does come up a lot in separation of powers cases, and you look at what the pattern has been, not only have the branches negotiated it out, but there has been a practice of these subpoenas, and broad claims of privilege or of presidential protection haven't been sustained. And so I think one of the things that Breyer was underscoring there is we've had pretty intrusive subpoenas of the president in the past. Why would we think this, which is going for this private information that isn't even privileged, is even at the level of what was sustained in the past?
Thanks very much for that. Andy, could you address that point Gillian just raised about history, which several of the justices raised? Justice Sotomayor said, counsel, there's a long, long history of Congress seeking records and getting them, as Justice Ginsburg pointed out. Ever since 1792, said Justice Ginsburg, we've asked for personal papers from the president. And these aren't even his papers, they're subpoenas to private entities, so I just don't understand. They're not even covered by executive privilege. And then Justice Kagan asked a version of the same question. She says, I think what strikes me is this isn't the first conflict between Congress and the president. What it seems to me you're asking us to do is put a 10-ton weight on the scales between Congress and the president, and to make it impossible for Congress to carry out its oversight function where the president is concerned. This isn't going to be the last case, and I wonder whether that fact isn't a good reason to reject your proposed rule. So what was the president's answer to that historical record, and what is your answer?
Yeah, I was a little bit frustrated by the historical comparisons because I didn't really feel they were analogous. First, with respect to the Watergate tapes, it's one thing to have a grand jury subpoena with respect to the president's records. A grand jury isn't bound by the same things that Congress is. We've been saying through this conversation that Congress, when it issues a subpoena, generally has to have a legitimate legislative purpose. That's not the requirement that applies to a federal grand jury. They don't pass laws. So just the mere fact that a grand jury has the authority to get tapes from the president doesn't tell you that Congress does. There are different legal standards that apply. With respect to the other historical incidents, again, these were voluntary disclosures. At oral arguments, it was referenced that President Nixon turned over his tax returns to the Joint Committee on Taxation. Well, he did that voluntarily, at least in a legal sense. There was a lot of public pressure, and he told Congress, I want you to examine my returns. There wasn't a subpoena for his records. In some of the historical cases dealing with Thomas Jefferson and so on, yes, there was a subpoena, but these were circumstances in which the president wasn't the target of the investigation. The president may have had materials that was relevant to someone else's wrongdoing. And so, yes, the president has been subject to process, but not in the context of a congressional subpoena, which is bound by the legitimate legislative purpose standard. Not to say that these historical examples aren't on point doesn't mean the president is correct here, but I think we're a little bit comparing apples and oranges with respect to the historical examples. It's a little bit too facile to just say because other presidents have turned things over, there's no difference here. With respect to the president's records being held by someone other than the president himself, again, that to me is a little bit of a red herring. Even if President Trump had a massive trove of documents on his own computer, if there was a subpoena for them, he himself would not sit there late at night categorizing, putting Bates numbers, documenting all the materials. He would still have to determine through consulting with others what materials were privileged, what was within the scope of the subpoena, and so on. In other words, there'd be a burden on him in the same way as there is a burden with respect to documents held by a third-party custodian. He still has a right to determine whether some of those documents may be outside of the scope of the subpoena or privileged. So for me, just the mere fact that we say, it's a legal term, we say that President Trump has standing to sue, that implies that he is harmed by the potential disclosure by the banks of his records to Congress. So he has a personal stake in this. Otherwise, we wouldn't be in court. So for me, I don't feel perhaps the same way as others do about the fact that the records are nominally held by someone else. As a functional matter, I don't think it makes that much of a difference whether it's held by Mazars or on his home computer.
Thank you for those points. That concern was echoed by Justice Alito and others several times, who noted that I'm hearing an echo, so someone can turn off his her computer. But Justice Alito said that, yes, in practice, we all know that they're going after the president, so the fact that it's after the accountant doesn't mean it won't be burdensome to him. And I also hear you say, interestingly, that in your view, the standard for a grand jury should be lower. As long as it's relevant, the grand jury should ordinarily get the information, whereas for Congress, you might want a higher standard, like being relevant to a legitimate legislative purpose. Gillian, Justice Ginsburg raised an interesting question about legislative motive, and she put it in a very stark way. She said, to impugn Congress's motive makes no sense here when even the policeman on the beat, if he stops a car and gives the reason the car went through the stoplight, we don't allow an investigation into what the subjective motive really was. Here, you're distrusting Congress more than the cop on the beat. And then in our great NCC chat room, we have Nicandro Iannacci, founded the National Constitution Center's We the People podcasts, and is now at Columbia Law School, where he's a star student. He asked, didn't the Supreme Court reject arguments about pretext in Trump v. Hawaii? Why shouldn't the court similarly give deference here to what the House says its legitimate purpose is? So tell us what your thoughts are on that question of pretext and whether the court should defer to what Congress says its legitimate purpose is. You're muted, now you're unmuted.
I don't know how I've done
do that all the time.
I think in general, the court, in many instances, has been reluctant to do purpose scrutinizing inquiries in legal challenges. I think it recognizes there are some instances where that might be appropriate, but particularly when you're talking about a co-equal branch, they are hesitant to do so. And I think Nicandro is absolutely right that Trump versus Hawaii is one where there was a very big deference given to the president's claim of legitimate purpose. I would be surprised if the court here goes on second guessing Congress's purpose for that very reason. And in addition, because if you look at the president is actually quite express in saying, we are not going to be second guessing. You don't have to prove, we're not going to be looking at your purpose. We're going to take whether or not objectively looking at the subpoena, it is connected to an area in which legislation could be had, for example. So I think the arguments were made, and I think what Justice Ginsburg was getting at, which was something that struck me in the argument, was the suspiciousness with which Congress was sort of viewed at times in the president's and DOJ's arguments and some of the questions from the justices. I mean, one of the interesting things, it's a separation of powers issue, and that means that there are two co-equal branches. And When Justice Kagan said you're putting a 10-ton weight on behalf of the president, what she's getting at is if we do that standard that protects the president so much, we're actually hobbling Congress in its oversight of the executive branch. And that kind of, the other thing that strikes me is how much distance we've gone over just like 20 years in terms of the degree to which a claimed concern about burden by the presidency is getting much more receptiveness today than it did, for example, in 1997 in Clinton versus Jones. Whereas the kinds of respect and deference for Congress that I think traditionally have gotten more weight, today you see Congress sort of viewed more suspiciously. I just want to make one final comment here. I actually think the fact that in the past it was done voluntary matters a lot. And I think it says something about, that presidents didn't think they could get away with big claims of resisting congressional process, and the extent to which actually the political branches can negotiate that out sometimes. And so maybe the courts don't need to come in. And I think that as a result, one of the things that is the background here in this case is the very resistant to any kind of congressional oversight stance that the Trump administration has been taking. And against that background, you're getting more categorical claims, whereas in the past, you would have negotiation on specifics of this subpoena or that subpoena, can you combine them, not having 3 committees and so forth. And I think that is actually part of our constitutional heritage, is that these things should be worked out by the political branches, but that means you can't give a very strong claim of privilege to one side, or that leverage to negotiate disappears.
Many thanks for all of that. And thank you for mentioning the Clinton v. Jones case. One of our questioners, Steve Carson, asks, the references to Clinton v. Jones brought back memories of a rather sleazy moment in presidential history. Can you remind us what was at stake in that case and who won? And Steve, was the case where Paula Jones accused President Clinton of sexual harassment. She said she needed information from him and wanted to subpoena him to testify. He said he had an immunity from having to testify in a civil suit because it would take up too much of his time. It would impede his ability to exercise the duties of the office of the presidency. And the Supreme Court, in a bipartisan opinion by the late Justice John Paul Stevens, rejected that claim and said the president was not categorically immune from testifying in a civil suit. The court was confident that it wouldn't take up too much of the president's time, and therefore he had to give the information. Later, Justice Stevens joked, well, we never knew that the president was going to lie under oath, so that's why it took up more of his time, because he chose not to supply the information when he should have. But so that's the answer to Steve's question. And then Justice Kagan also pressed Clinton v. Jones. She said of the president's lawyers, go back to your use of Clinton v. Jones. Clinton says you're supposed to treat the president with respect, but the fundamental claim of presidential immunity, or even the idea that the president was different from another litigant, was rejected in that case. And what I'd like to know is why you don't argue that these particular subpoenas place a particular burden on the president, so he'll be prevented from carrying out his constitutional responsibilities. That's the kind of thing the president ordinarily has to show in order to prevail in resisting subpoenas. So Andy, tell us about the president's response to Justice Kagan's question, and why President Trump believes that Clinton v. Jones doesn't preclude him from turning over the papers.
Well, certainly as a factual matter, I don't think society will grind to a halt if President Trump has to comply with these subpoenas. That's certainly true. It's mechanically possible. He has lots of advisors. He apparently has lots of free time. I don't think society is going to end if he has to comply with the subpoenas. However, that is not the categorical approach, the long-standing, forward-looking approach that the Supreme Court uses in these cases. The question isn't whether any particular subpoena will burden this president. The broader question is, President Trump is not going to be president forever. Democrats won't always control the House. Republicans won't always control the Senate. They need to set a rule that's going to apply for future generations. Now, in Clinton v. Jones, it is true, and now it's an almost infamous line. The majority opinion said, we are looking back at the last 200 years, and we are blessing subjecting the president to civil process in federal court. And given the last 200 years, we don't think it's very likely that the president will face a deluge of litigation. That's just not going to happen. Well, pick up your newspapers from the last few years. The president of the United States, whether you think it's his fault or not, is subject to a deluge of litigation over his Twitter account, hush money payments, everything imaginable. So I think the lesson of Clinton v. Jones maybe it's a double-edged sword here. On the one hand, the president may be subject to judicial process at the federal level, set aside the congressional source of the subpoena, but at the same time, I think it gives us a warning and I think it'll make the court think hard, not about are these particular subpoenas a burden on the president? Really, the broad question is, if we accept Congress's standard for validating a subpoena, will that very low standard burden the presidency in the future? And that is why the court was giving the House's counsel such a hard time. They were looking for a limiting principle for the future, and the House's counsel just could not admit, it seemed, that any subpoena would ever be invalid. And that's going to raise some concerns with the justices when they finally have to decide this case.
Thank you for noting that. Thank you for noting that the concern about future presidents was shared by justices on both sides. In fact, Justice Breyer said, the question is that this will apply to a future Senator McCarthy asking a future Franklin Roosevelt or Harry Truman asking the same question, so what do I do? And Lawrence, present in our chat box, says, did I understand Justice Breyer correctly when he raised the prospect of a future Senator McCarthy plaguing a president of the United States if the legislative purpose stated for the documents or information is too broad? Gillian, how did you understand Justice Breyer in that regard? And where do you think that he would be inclined to draw the limiting principle?
I did. I mean, as I think I said at the outset, what did strike me is I thought across the court, the justices were concerned for a limiting principle. They wanted to know, how do you protect against harassment? And I think they were attuned to that concern and attuned to it. And I think, interestingly, maybe more so than they had been in Clinton versus Jones when similar kinds of concerns were raised. And I also agree. I think that the counsel for the House struggled to give a limiting principle that would satisfy the court, in part because if you focus on if it's just an area where legislation could be had, and you also acknowledge how broad Congress's legislating power is, that doesn't seem much of a limit, as I think some of the justices said. On the other hand, I think there were some others that were identified. I would note the one about pertinency, and I think that can be used for the case study concern, for example. If you're legislating broadly on a topic like, medical care in the United States, it's hard to see why the president's health records would be particularly pertinent to that. My guess is he probably, among other things, has better health care than most people in the United States. So it doesn't, you can do more with pertinency than I think got traction at the hearing. And then, of course, the other point is you also have the protections of the Bill of Rights, which particularly relevant for McCarthy analogy, and Article 2. What's interesting is when you get to Article 2, though, the test that was established in Nixon versus the general administrator and continued on in Morrison and other cases, and even invoked more recently by the court, is whether or not something interferes with the president's ability to perform his or her constitutional functions. I think that the House was very willing to go with that test, which has been the court's traditional test. The president and DOJ were not. They wanted a higher standard of protection than that. And again, they wanted something categorical. The other thing that the House, I think, was willing to offer, although did not stress that much, and I thought that in the second case, the counsel for the district attorney did a very good job of emphasizing this, is that it can be done on a case-by-case basis. And this came out in Clinton versus Jones as well. Courts are able to step in and protect abuse. Particularly, when you're going after the president and it looks like harassment, and smells like harassment, federal courts are able to step in there. And I think that's another protection that shouldn't be discounted as a way of ensuring that these kinds of subpoenas don't get out of hand.
Thank you for that. Andy, both Justice Gorsuch and Justice Kavanaugh asked the practical question of how Congress could meet the heightened standard. Justice Gorsuch said, my question is more practical. Why isn't this subpoena supported by a substantial legislative need? The answer was the Congress hasn't specified with any specificity what legislation it could enact with respect to the president in asking for documents going back over 10 years. And in response to Justice Kavanaugh, the question of how you meet the Nixon critical need standard, the answer was, in a case where Congress says it's considering general legislation, it would have to be very difficult. You can't just have one sentence asserting the need and would have to be more specific. So Andy, can you answer the practical question? In your view, does Congress have to say in advance what it's planning to be legislating on and enumerate that with some specificity or not?
Well, it shouldn't be too hard to provide a couple lines. Most congressional subpoenas are upheld, and Congress doesn't have to write a 1,000-page statute first to explain why it wants information. Really, I think they shot themselves in the foot here because the subpoenas were so broad that it makes you scratch your head as to what potential legislation could be served. Why? What is the spending habits of, or the spending related to Donald Trump's 4-year-old grandchild? How is that potentially relevant to anything that Congress is doing? It's a very strange demand that every check, every credit card swipe on behalf of his entire family, including grandchildren. And so with respect to the specific standard here, if the subpoenas were narrower, they probably would have had a better chance of being able to articulate in just a couple lines, and they don't have to write 1,000 pages to explain why they need what they need. But if the requests were narrower, I think it would be a lot easier to satisfy the standard. But if you ask for a billion strange things that to a person on the street knows has nothing to do with the legislation, yeah, you're going to have a hard time articulating a particular legislative purpose to justify such wide demands.
Thank you for that. Gillian, Andy says that if the subpoena had been more narrow, then Congress could have justified it more convincingly. And yet Brendan Flynn in our chat box at the National Constitution Center says, even assuming Congress can't legislate on the topic of the president's conflicts of interest, what about the president's family members who may have been involved in his businesses and are now employed within the executive branch? Wouldn't some of this financial information be relevant to legislation with respect to conflicts for those persons? So what is your answer to that, Gillian? And more broadly, the question suggests, you can go broad or you can go narrow, but since almost anything, whether related to the president or not, could conceivably be relevant to some sort of regulatory investigation, how are courts supposed to evaluate those purposes without intruding on the separation of powers?
Yeah, I'm less, I think that the claim that these were, all of these demands were too broad, I'm less persuaded by. I think that, hidden in this question and hidden in this area is this issue of to what extent can Congress legislate conflict of interest that would affect the president's family or the president, or financial disclosure. If you accept that Congress can, and I think to rule all that out is, again, as I've said, I think a couple of times now, a pretty broad claim of Article 2 immunity from Congress, then it's harder to see what could come from these subpoenas. I think if you acknowledge Congress has legislated in these areas and has important roles in legislating these areas and in the, enforcing and developing and fine-tuning ethics regulations, then I think these really aren't too broad. You really do run into a problem for Congress if it has to identify with specificity whenever it's seeking something that could impact the president, and has to go further along in terms of identifying what the specific legislative measure might be. As I said, I think earlier, Congress does have an important role in sort of overseeing the executive branch. It's an area where legislation can be had. But it doesn't mean that legislating is always the primary purpose. It can also be to investigate, to keep a running tab on where problems are arising as part of that oversight function. And it is towards an eye towards legislation, but the legislation could be really down the road. And I think that falls within Congress's legitimate scope. So I'm not, I would draw a distinction between what we've talked about at times, the case study, Financial Services Committee argument for the subpoenas, where again, I think that's a little dicier. Certainly, I think the health records hypothetical would probably be I think beyond the pale. But the ones from the Government Oversight Committee and the Intelligence Committee, I think sort of do fall within Congress's legitimate subpoena power.
Thank you so much for that. I think let's put on the table the next case. And we can tie them all together at the end. But the case Trump versus Vance involved the question of whether a county custodian, namely the New York district attorney, could subpoena the bank for financial records over which there's no claim of executive privilege. And the president's lawyer, Jay Sekulow, began by saying no county district attorney in our nation's history has issued a subpoena against a sitting president, and argued for temporary constitutional immunity required by Article 2. In other words, the president couldn't be forced by the local district attorney to turn over the information at any point during his presidency. Noel Francisco, the Solicitor General of the United States, arguing for the United States, took a more narrow position and said there shouldn't be complete immunity, but there should have to be a heightened standard. And once again, it's the same standard that came from the Nixon case, a demonstrably critical need for the information rather than the ordinary standard for grand jury subpoenas, which is the information relevant to a legitimate investigation. So Andy, tell us about the Solicitor General's argument. In both cases, the United States is arguing for that Nixon standard to be applied in a case where it had not been applied before, namely to personal records not claimed by the president to involve executive privilege. But the difference between the two cases is this one involves a state district attorney and the other case involved Congress. So how did that standard play out differently in this case, and why do you believe the president was correct to argue for the heightened standard in the Trump versus Vance case?
Yeah, so as you pointed out, the DOJ, the Solicitor General, is arguing for a limitation on state grand jury proceedings using a standard from a different context. That is, the heightened need standard is borrowed from a context in which you have privileged materials. So the question is, well, they sound like different contexts. Is that just crazy? Well, I don't think so. And the reason to keep in mind is that we have a state proceeding here. Clinton v. Jones, that case in which President Clinton was sued in federal court, and the Supreme Court held that President Clinton could be subject to civil process in federal court. The court was very clear, not a mere footnote, but in the text of its opinion, it said, things may be totally different if a state court is involved, a state court civil process. That raises serious constitutional concerns. We're not just going to bless state civil process against a president. Well, here we have state criminal process against a president. So alarm bells are going off. This is an issue that the Supreme Court has declined to touch before. So what do? We have some signs that this is not a run-of-the-mill scenario. Usually if a grand jury wants bank records, I think the standard in New York is something like there has to be no conceivable relevance or something like that, something extraordinarily low, just because prosecutors get financial records all the time. But in light of Clinton v. Jones and the Office of the Presidency, I believe the Solicitor General was looking for a higher standard. And I think it makes sense when we're lawyers, when you're coming up with a legal standard, why not look at legal standards that have been used in other contexts? Again, that standard applied in the context of executive privilege. It's not on all fours, but it provides some convenient language to use in a context when you're trying to heighten a standard for a subpoena. And I believe that is why the Solicitor General used it. Is that a perfectly fine-tuned standard? I'm not sure. From what I gather, the Solicitor General first advanced this theory in this litigation alone. We do not have a lot of DOJ memos on this. We have not had state prosecutors trying to subpoena the president's documents or documents held by a custodian. But I think the Solicitor General is trying to bridge the gap between Mr. Trump's position, which was, I'm just completely immune. The New York's position was, well, just apply the normal standards. And I think that is where we get this heightened need standard. Seems like a reasonable approach. And I thought that some of the justices seemed receptive to that middle standard. And at least from the parts that I was able to listen to, it didn't seem to break along ideological lines.
Interestingly, thank you for that. Friends, just to recap where we are, and Andy and Gillian are doing a great job. The first case involved subpoenas from Congress. The leading cases, the Doherty case, which we've talked about, generally said the subpoena has to be issued for a legitimate legislative purpose and not to investigate the president or not to expose for its own sake. The second case involves a subpoena from a state prosecutor and grand jury. And the question here is, what should the standard be? And the Solicitor General is saying the standard should be the same one that the government is arguing for in the first case, which is some demonstrable or critical need for the information. You shouldn't just be able to get it because it might be relevant. Now, Gillian, Clinton v. Jones seems even more on all fours, as they say in this case, than in the other, because this involved a civil or criminal proceeding, not a congressional subpoena. And Justice Gorsuch asked straight out at the top of the argument, how would you have us distinguish Clinton v. Jones? Yes, it took place in a federal court, but it was a civil case. There could have been multiple versions of that in different districts in the country. How do we avoid the conclusion that the president wasn't subject to special immunity, but is here? And the answer, that was a lawsuit. And here there are multiple lawsuits. And the Clinton case was concerned that local prejudice could impact the president. So state courts are different than federal courts. And Gorsuch said, how is this more, Justice Gorsuch said, how is this more burdensome than what took place in Clinton v. Jones? I'm not sure I understand that. They sought the deposition of the president when he was serving. Here they want records from the third party. And the answer was, what's to stop them from seeking a deposition of the president or having him appear before a grand jury? And then the final part of this colloquy, Justice Kavanaugh says, explain if you can the rationale for having one rule for criminal cases and the other for civil cases. So Gillian Metzger, what do you make of all that? And how did you hear the justices trying to distinguish Clinton v. Jones?
Yeah, so I do think Clinton v. Jones got much more play in this argument than it did in the prior one, although it had some relevance there too. And I mean, one of the interesting things about Clinton versus Jones is that the court there was sensitive to the possibility of the president being targeted, but also required the president to do a sort of initial showing of burdensomeness. A lot of what is going on in these cases is who bears the burden when. And so the president and Noel Francisco, the Solicitor General, the president wants this absolute rule of immunity. I didn't get much sense of much interest in that on the court, to be honest. I'm interested in what Andy thought, but I thought that the categorical did not get a great reception. But there was a lot of concern about burden on the president. And then the question, the Solicitor General was trying to say, well, yes, given that potential, we need a greater show. There should be a heightened showing before you can go for the president. Now, of course, what Clinton versus Jones said is, well, first you have to show the burden on the presidency, and then it flips to the other side to have to show why there's a specific need, why it's not available elsewhere, and so forth. So already the Solicitor General is trying to move us beyond where we had been in Clinton versus Jones in a more president protective way. I think among the justices on the court, my sense is they are really kind of trying to figure out what the standards should be among a range that were suggested. So you have many different variables here. First, you have this civil criminal difference. And you can weigh the burdens of that different ways. On the one hand, criminal, possibility of prosecution, yeah, that's a pretty big deal. There's also the concern that these are state DAs, state courts. State DAs are elected officials, many state judges are. Concerns about the use of state process in a politically desirous way are in play. On the other hand, civil, Clinton v. Jones, sexual harassment, as I think Justice Breyer said, I may be getting that wrong, that can be pretty embarrassing, right? So there could be a lot of burdens there. I think it's fair to say it took up a whole lot of time with the president. So, how you figure out which is more burdensome, I think is tricky. I think that's one thing that justices are weighing. the New York, I thought, I actually thought the argument from New York was quite strong and very sensitive to what these concerns would be. One of the interesting things is New York is conceding that the federal court would have to be available to review. So the state factor is really mitigated here. Yes, it's a state proceeding. Yes, you've got the electoral officials thing, but you have a federal court there to protect the president, and that that's been conceded. So that's sort of off the table. Then I think that really the difference turns on whether or not the president has to make some showing of what the burden is, and some claim of privilege or some claim of why this is going to be so much more time consuming. And if the president does show that, then it turns to the burden turns to the prosecutor and the grand jury to show why you need to ask the president for this information. What's the specific need? Is it not available elsewhere? The other thing to note about criminal proceedings is, first of all, the court is generally quite deferential to state proceedings and state grand juries. Grand jury is not a trial, and one of the things that the state identified as a concern here is that the standard the SG was identifying really related to trial subpoenas and didn't fit so well with a grand jury, which is really an investigation. So it's harder to identify the specific need up front. It's hard if you have to go right into court. And that I think is going to play with the court some. Grand juries are subject to rules, and they're subject to confidentiality. There are a lot of protections that are sort of baked into the process. I think the court will be sensitive to that. But I was struck by how much sort of fine tuning of what the standard should be. And I agree with Andy, I didn't get a sense of a stark ideological divide on the court. I thought they were all sort of struggling with how to make first of all, what the difference was between the New York and the Solicitor General standard, and how to make it really work the right way to take the different interests into play.
Yes, that's very helpful. And I heard that too, that the justices on both sides were struggling to figure out what the difference between the standards was. So it was very striking that the attorney for New York, Carrie Dunn, the New York County District Attorney, proposed the standard that you just mentioned, Gillian. He said, if there's an affirmative showing by the president of an Article 2 burden, in other words, he can show it really would take up a lot of his time and make it hard for him to do his job, then federal courts should be opened to evaluate whether first there's an objective basis for the investigation, and second, a reasonable probability the subpoena would yield that relevant evidence. And then Justice Alito said, well, could you ask whether you could get the information somewhere else? And he said, yeah, that might be relevant. And then Justice Sotomayor said, hold on a second, that sounds like a more demanding standard than the ordinary one we apply, which is just, is the information relevant to a legitimate investigation? And she and Justice Kagan said, why don't we just ask the usual standard, whether there's credible suspicion of criminal activity and whether the subpoena is reasonably calculated to advance that investigation. So Andy, for our friends who are not lawyers, explain what the difference between the government's proposed standard, namely a demonstrable or critical need for the information, and what New York's standard, which is that there's some objective basis for the information and it's likely to yield information is. I mean, why is this important in practice? And could you imagine, since both you and Gillian have said that you didn't see a strong ideological divide, could you imagine the court converging on a bipartisan or multi-partisan standard of various justices? And if so, what would that consensus standard look like?
Yeah, it's very hard to say from these oral arguments. Sometimes you watch a Supreme Court oral argument and everyone's talking about just one specific narrow issue, and you get a sense of this person believes this person believes that. But these ones really had a lot of moving parts. So I don't know whether we're going to have a 3-2-4 opinion, 5-1-1-1, something like that. But I think in terms of the different standards, I think Gillian put it nicely. I suppose, really, do you put the president in a defensive posture at the outset, provide some showing for a special rule, or do we categorically provide him with a special rule and then impose on the DA the obligation, the burden to show that, well, I can't get these records from somewhere else. I really need these records for this investigation. The records are from the president, but they relate to someone else. Therefore, I'm not going to burden the president. He's not the target of the investigation. And in the briefing, the New York DA was clear that just under New York law itself, there are various defenses that a person can present against a grand jury subpoena. They're not very robust, again, because grand juries typically have quite a bit of latitude. But I can see why the president was a little bit concerned, and the DOJ, about, I suppose, I forget the justice who said it, but why not just apply the normal rules? Well, the normal rules will be the grand jury's going to get virtually whatever it wants, even if you provide a little bit of special respect to the president. Under the normal standards, the grand jury has an extraordinary important function in our society. And I think that's why the Supreme Court is very mindful about this. The Supreme Court can't trample on state courts and grand juries. There must be quite a bit of respect shown to those institutions as well as to the president. And that's why we have this fascinating and thorny issue. And I'm glad I don't have to decide that one.
Yes, but you do have to explain it, and you're doing it. So is Gillian. Gillian, there's a remarkable sense of symmetry for me. I became interested in the issue of privacy during the Clinton and Jones case when I was so struck that the court said it was okay to subpoena even private diaries of Monica Lewinsky, whereas at the time of the framing of the Constitution, it was a general warrant for private diaries and private papers that sparked the American Revolution. And in trying to understand how that happened, I came to learn that it was really a series of cases starting in the progressive era that said that we couldn't enforce federal regulations if businesses and others could resist subpoenas from Congress or from federal bodies by insisting that they were private. And the result was that we live in this world where, according to our Enterprises case, which sounds so technical but is so important, generally any information that's relevant to a legitimate investigation can be seized no matter how private it is. So what's so interesting about these two interesting cases is here the court is confronting for the first time since Clinton v. Jones the idea that the president is special. There's only one president. The president is a branch of government, the Solicitor General said several times, and therefore he should be treated differently. Justice Ginsburg was skeptical about that. She's saying ordinarily the grand jury can get any information it wants for any person except for the president. Is that what you're arguing? And essentially, Gillian, is that what you heard the Solicitor General arguing? Was the answer yes? And that because he's the president, and even though he's susceptible to subpoenas for civil suits, he should be held to a different standard because why? Because state courts might abuse him for political reasons, and there are a whole lot of state prosecutors, and therefore we have to create a new rule for him?
Yeah, so I think, I would say, I think the president's lawyers were saying, except for the president, this kind of categorical exemption really would put the president above the rule of law. I think the Solicitor General was that might have been his first best choice. I think the Solicitor General actually figured the court probably wasn't going to go for that and was arguing, as we've been talking about, something a little bit more restrained. How much restrained, how much the president ends up being protected, of course, turns a lot on what the standard is. And that's where the disagreement is. I think the arguments are this concern about harassment of the president, and there is also this kind of formalistic, the president is the executive branch idea that comes into play as well. I really am struck by the contrast to the reasoning in Joe's. I mean, 1997 case, not that long ago, right? And first of all, it was essentially unanimous. You did have Breyer concurring. Breyer was the one who was maybe most concerned about the impact on the presidency, but otherwise this was not an ideologically divided case. And it was a real affirmation of the principle, the president is not above the law. I actually kind of think that the court on this one may try to come together. I think absolutely, I agree with Andy, there's going to be maybe some differences about what the specific standard is and how you apply it. I think they would probably try their best to come together because I think it really is important in these cases that you not have that kind of ideological line on a basic principle that the president is not above the law. The other thing to point out is that you can protect the presidency again by this burden shifting. The real question is, nobody is saying there's no protection for the government, for the president. Even the justices who are saying, would we do the ordinary standard? I don't think they were saying there wouldn't be protection for the president. I think what they were saying was, would we do the ordinary standard? And then if the president comes in with a claim of privilege, which again is or a claim of burden, that's the argument of Jones, then we would require something more. Versus at the get-go requiring more because it's the president. I think that's where the difference lies. But I think everybody kind of acknowledged that the president may need some special protections here, as the court did in Clinton versus Jones. The question is whether they're going to provide them at the outset without the president having to show anything, or whether they're going to put the president to some degree of proof of burden before they call that apparatus into question.
Interesting, and thank you for noticing the question of when the president has to make his showing is crucial. Andy, I'm not asking you either to predict or to solve the case, because that's way above all of our pay grade. But as Gillian says, Clinton v. Jones was nearly unanimous, and Chief Justice Roberts cares deeply about the institutional legitimacy of the court and has worked so hard to avoid 5-4 decisions on partisan lines, especially in cases with high political valence. Imagining, as I do, that he will be eager to come up with some kind of consensus ruling in this case, on the thought that it would not be good for the court's legitimacy to have ruled unanimously against President Clinton in a civil case and divide in a criminal case for President Trump. What would the standard, what could the standard look like? And what, is there a standard that you, as an advocate of executive power, who's argued so powerfully that the president should have his Article 2 interest protected, is there a consensus standard that you could live with?
Yeah, I'm sympathetic to the heightened needs standard. And if the Chief Justice needs a consensus approach, I thought the Solicitor General offered a somewhat of a way out. Remand now and let the lower courts determine whether the heightened needs standard, which the court, I guess, would have invented or embraced for the first time, has been satisfied. Let those proceedings continue. And then later on down the line, if that standard has been satisfied, then the Supreme Court, if necessary, could decide whether the president in fact has absolute immunity. But one way out is we're not even going to decide the immunity question. Let's just first figure out if the heightened needs standard has been satisfied. And then if it has, then we will get into this absolute immunity question. I don't think that the president being immune, even absolutely, is as big as a stretch as we might think. That is, it's black letter law that a Texas grand jury cannot investigate the Department of Justice. It's black letter law that a Kansas prosecutor cannot indict the Secretary of the Treasury for his official duties. States cannot subvert the federal government. The question is, here, does a president get even more protection on a temporary basis, not forever? This is temporary claimed immunity until he leaves office. Does he get more protection than we already know and we already acknowledge is given to inferior federal officers? So viewed that way, I don't think that this is really about, can the president shoot someone on Fifth Avenue and get away with it? It's a matter of, while in office, do we not stigmatize a president through criminal process? And once he's out, all the normal rules turn back on. So I don't feel, to me, the phrase above the law doesn't tell me much. I want to know what the law is first, and then I know whether someone's above or below it.
Thank you for that. Thank you for articulating a standard that I think I heard General Francisco articulate too, that the court should embrace a sort of heightened or critical needs standard, send it back to the lower court, and have it decide on that basis before deciding whether the president has absolute immunity. Gillian, though, as I heard the argument, I didn't hear the more liberal justices being willing to accept that standard. They seem to suggest, Justice Kagan, Justice Sotomayor, and Justice Breyer all said, why don't we just apply the standard we usually do, and that we do in ordinary subpoena cases for grand juries, and that we did in Clinton v. Jones. And I guess I'll ask you, do you agree that they were not inclined to accept the heightened needs standard? And if that's right, can you imagine some compromise that's requires a little bit more of a showing than the ordinary case, but doesn't create an entirely new standard for the president?
Yeah, I don't think there's going to be consensus on the heightened needs standard from the very get-go. I don't think there was. I'm not even sure all of the conservative justices necessarily. They might be more inclined in terms of stronger beliefs in presidential power, but I didn't get a sense that they were necessarily fully on board. I think what I would expect to see more is, if there's going to be a consensus, some requirement that the president has to invoke Article 2 in some way. And that way could be pretty slim. So the president has to articulate some burden from, some plausible burden or some claim of privilege. And then it switches, the burden switches to the other side to justify. And it would turn a little bit on how much the other side could really show, for example, if they couldn't get the information elsewhere and so forth. So I think that the way, I agree with you, by the way, in your assessment of what Chief Justice Roberts would like to do here. And I think the way to do it is to say there has to be some assertion of Article 2 privilege by the president of Article 2 privilege, of article burden, some kind of Article 2 claim at the outset. And then we're going to switch to this either critical need or some kind of heightened showing supervised by a federal court. There may be one or two votes for the absolute immunity, but I don't think at this point that, to my reading of the court, is something that a majority wants to engage with.
That's a fascinating suggestion. And C-SPAN listeners, you're hearing the three of us try to think through in real time how the court might weigh these competing options. And Gillian just made the very interesting suggestion that the president should have to do what he has not done in either of these cases. He should have to say, my ability to fulfill my office as president of the United States under Article 2 of the Constitution is being burdened by this subpoena, and then the burden shifts on either Congress or the grand jury to prove why it needs the information. I should note that Jonathan Broder in our chat box says, but that leaves the president largely immune from process. The lower courts already found that this was not burdensome, and Trump did not argue it was. He's arguing that he's completely immune. That's right, Jonathan, but Gillian is suggesting that as a legal matter, the Supreme Court could say that the president should have to make some kind of claim that his constitutional functions are being impeded before the burden shifts on the other side to show why it really needs the information. Let's take one last beat on this, and then we should have closing arguments. Gosh, this is such an interesting discussion of two obviously absolutely fascinating cases. Andy, how about Gillian's standard? I mean, here, the president in none of these cases actually invoked executive privilege, Article 2 burden. The Nixon case, as many of the justices said, was one where he did. He said, I'm going to be really burdened. And even then, Justice Ginsburg said he had to turn over the tapes. So what would you think as an executive power of a compromise like that? We're just thinking this through, brainstorming, as they say, that would require the president to invoke his Article 2 interests before the burden shifted and the standard was raised.
Yeah, so one I would point out, just with respect to the lower court proceedings in this case, they moved very fast. I didn't feel that the lower courts really made a meaningful inquiry into the factual arguments made by the president with respect to the subpoena. Two, I'm inclined to think that the mere fact of being subject to criminal process by itself burdens the president, just as a categorical rule. Maybe I'm just scared of going to jail. I don't know. But to me, it's just obvious that if you're subject to criminal process, obviously that's going to burden you. So for me, a boilerplate explanation of why potentially going to jail would burden Article 2 exercise of authority would be fine with me. So I suppose maybe it would depend on how robust this requirement of Article 2 burdens has to be. And to me, it's obvious, or from my, not obvious, but for me, I feel strongly that being subject to criminal process is per se a burden on the president, on anyone else, just as a flat rule.
Great. Gillian, last sort of review of the arguments, and then we'll have our closing statements. There was so much interesting in the arguments. What do you want to highlight about comments from justices in either case or both cases that struck you as unusually revealing about which way the court was going?
Sure. So just one thing to note at the outset, actually the president isn't subject to the process here. Isn't subject to the criminal process at all. It's third party going for the bank records. So, yes, and it isn't even necessarily the only target. what struck me, so there were a couple of things that struck me. What struck me about the second argument that we've been talking about is how quickly we were in the weeds of what the standard should be, or how do we balance this out, as opposed to the big constitutional frame-up of state versus federal government or president versus state kind of situation. I got a real sense of the court being much more interested in the nuances in that case, and I thought that was quite interesting. I did not think that they went for the sort of broad categorical immunity claims that were being made, and there was more sensitivity to the state interest. The thing that struck me about the first argument was actually I was surprised by the lack of real concern about Congress. It came up, but there was a real ideological divide there. And there was much more across the board solicitation about the state's interests in the second case than there was across the board solicitation about Congress's interests in the first case. And I think that's quite revealing, and it reveals something about how we've come to view the relationship between our political branches, and not necessarily an inspiring thing. I think it might affect, it strikes me as it's going to be harder to reach cross court consensus in the first case if there isn't more weight given to Congress's interests as well as to the president's interests in that case.
Thank you for that. I need to ask just, there's so many great questions from our viewers. I'm going to give Andy this question, which has come up from some two viewers. Mel Schuster asks, is the DA grand jury's position stronger or weaker than that of Congress? Isn't one major concern for the DA that the statute of limitations will render the claimed temporary immunity permanent? The civil discovery rule is an example of a court-created way around the statute of limitation concern, but it does not now exist. And Gary Lauder, hi Gary, it's great that you're here, asks, what are the implications for the statute of limitations? Would it continue to run if the president was shielded until he leaves office? So Andy, I'll ask you to address both of those questions about the statute of limitations, and then tease out any final aspects of the oral argument that struck you as especially familiar.
Yeah, I'll answer the second one first, because I definitely don't know the answer to that. There is a debate as to whether, if the president is immune, do statutes of limitations get told with respect to him? I've seen persons argue both ways. My gut feeling is that those aren't the circumstances in which you would ordinarily toll a statute of limitations. That could be totally wrong, but that, I would say, is a thorny issue. Can you just halt a statute of limitations when someone is immune? If you can't toll the statute of limitations, then I think obviously the practical concerns become extremely exaggerated, because the president could never be prosecuted if he's in office for 8 years and you have 4 or 5, 6 year statutes of limitation. So that is a major issue, and maybe one that needs to be addressed by legislatures going forward. As to the first part, is the DA's case stronger or weaker? I guess we didn't talk about the details of what the DA actually did. It's very strange. 2 congressional committees requested documents from Trump, sent the subpoenas over, and Mr. Vance, the Manhattan DA, copied and pasted those. And he also, because those subpoenas did not ask for the tax returns, Mr. Vance also copied and pasted a subpoena from the Ways and Means Committee, the tax committee of the US Congress, and sent those over. To me, this is very troubling. From what I can tell, he is investigating some local New York City business records law, and he has asked for all this information that relates to Russian interference, federal elections, international banking, and investigation into the IRS. And that, to me, strikes me as very strange. On the merits, if we get into this heightened needs standard, I think a district court judge will scratch his or her head. Why do you need exactly what investigation into Russia requires? The DA has also asked for, with respect to things available elsewhere, he wants Trump's tax returns. His state surely has them. Trump has properties in New York. There's no doubt he files New York tax returns. It's very likely he has to attach his federal tax returns to his New York tax returns. The state of New York has them already. The Attorney General of New York can have his tax returns. Local prosecutors don't get them. instead of working with his own government to get these documents that they surely already have, he has decided to subject the president to criminal process. Now, I guess I understand that it's to banks and not to him personally, but Mr. Vance has abandoned the argument at the Supreme Court that this is just purely to, just like any other bank. His brief was all about the fact that he is going after unofficial acts as opposed to official acts. So on the merits, if we dig aside from all the legal issues, I find Vance's position very strange on the merits.
Thank you for that. Gillian, one last question in brief response to keep the order as well, so you both do your closing arguments in the right order. Responses to anything Andy just said, if you need to, and then Blake Doty asks, the framers obviously intended the president would not be able to be indicted. However, did they intend for the president to be totally immune from all criminal proceedings? If the president is really immune from criminal proceedings, wouldn't that mean he is above the rule of law? And Justice Ginsburg asked a similar question. Is the president supposed to be above the law? And of course, that's the question that is lurking or openly presented to us in both of these cases. To what degree is the president's special constitutional duties under Article 2, does that entitle him to rules that are not applied to everyone else? So what are your thoughts on that question?
Right, so, I mean, I think Andy mentioned the point about it would be temporary immunity, and there are various, if you're talking about a prosecution aimed at the president himself, that's obviously one I think that would be told. So that may be a partial answer there. I think if you're talking about a prosecution of the president, I think that really does sort of raise, like a state prosecution of the president, I think it does raise some of the federalism and the part taking over the whole concerns that have been identified in this brief and in this case. But in this case, the real issues I don't think rise to that. Again, this is a third-party subpoena. There are other ways of getting at and protecting the president through requiring some assertion of some kind of burden and then more specific showing. And so in this case, if you were to give that kind of blanket across the board temporary immunity, I think then you do start risking the issue of the president being more just really above the law and an ordinary legal process while in office. And at a minimum, then you have to take on Clinton versus Jones. I mean, the court would have to overrule Clinton versus Jones, I think, to adopt a kind of position of a categorical exemption. Yes, that was civil and this is criminal, but I think it's very hard, and I think the court was struggling with this. I think it's very hard to adopt the categorical position and adhere to Clinton versus Jones, which said actually the president is not above ordinary legal process, at least not without showing some reason why the presidency needs that kind of protection. So again, I think you have to be very careful and nuanced about the specific context and claim that's being made against the president and the way the burden is falling on the president. And in this case, I think, I disagree with Andy about the degree to which this is burdensome on the president. And I also think that the lower courts and the federal courts have been involved and bless what was going on in terms of whether or not there was a legitimate claim for the subpoena in the grand jury context. Again, the grand juries do have a lot of protections about them as well. So I think that we need to take those into account in assessing the burden.
Thank you so much for that. Well, it's time for closing arguments in this remarkably rich discussion. It's extremely hard to condense into just a few crisp sentences the essence of your position, but I'm going to ask you to do that. You heard the lawyers on the argument do so wonderfully well in condensing their positions. And Andy, the first of the last words is to you. And the question is, tell our great C-SPAN and National Constitution Center viewers why you believe that the president should not have to respond to subpoenas from Congress or from grand juries unless both of those bodies can meet a higher than ordinary standard showing some demonstrable or critical need for the information.
Yeah, I suppose I would just tell them to rewind on their TV and watch the last hour. So I'm gonna dodge that question because I can't answer it in 2 sentences. I have a couple articles on it. I will leave with a closing remark unrelated to a doctrinal point. For those listening or have made it this far, you'll see that me and Gillian disagree on kind of a lot of these sub-issues. that Gillian has a broader view of Congress's power to impose financial disclosure requirements on the president than I do. And I bet if you asked Gillian the same question 5 years ago, she would tell you the exact same thing. If you ask her 5 years from now, she will have the exact same approach towards Congress's regulation of the president, and ditto for me. And I think for those voting at home, because so many of these cases feel politicized, some of us just have different ideological vantage points, and that explains the difference of opinions. Just a different point in the analysis, we just view things differently aside from a current occupant of an office. No man's an island, no woman's an island. We're all aware of greater context. But for people who watch these cases, I hope they're aware that there's more things going on in these disputes than I support my guy or my gal or I hate the other side. There's a lot of really interesting legal issues. And that really, I think, explains a lot more division in the bench than I think is often appreciated.
Thank you very much for that. And I must thank you for exhorting our great viewers to separate your political from your constitutional views and to try to approach these cases in a legal and open-minded spirit, which is exactly what we're doing by having this rigorous and illuminating conversation. Gillian, the last word is to you. National Constitution Center panelists, unlike Supreme Court advocates, are allowed to dodge the moderator's question, but I'm still going to pose the same one to you, and you can answer it or not as you like. Tell our viewers why you believe that the president should not be subject to a heightened standard of critical need when confronting a subpoena by Congress or by a grand jury.
Right, and I honestly, I think that the answer relates very much to what Andy was saying there. I think it has to do with stance of view of the Constitution and the separation of powers. In my view, it is better to avoid absolutes, to have acknowledged that our history is one of negotiation among the branches, of not exaggerating executive power in our constitutional frame. I think as a practical reality, executive power has grown tremendously over time, and the more Congress is polarized ideologically, it will only grow more so. And I am less concerned about protecting the executive branch, and I see less of the kind of absolute protection of the executive branch than some, than maybe Andy does, but certainly than some backers of a very strong executive in the Constitution view, and then President Trump's lawyers argued for here. So what I would hope to see is decisions from the court that acknowledge that need for taking into account both branches' interests, and therefore requiring the president to show more before he is exempt from either congressional subpoenas, or his records are, again, he's not subject, or from state process, and to really try and stick to the tried and true strategy of looking at things case by case, weighing interest case by case, and recognizing that the federal courts are able to protect a wide variety of interests in that fashion.
Well, thank you so much for that creative and illuminating suggestion that the president have to show a heightened interest, a constitutional interest, before he gets closer protections, and also for joining Andy in exhorting, and now I'll thank our viewers for approaching this in the spirit of constitutional law rather than partisan politics, and recognizing that people can disagree thoughtfully and respectfully about these hard cases based on your view of separation of powers and the balance between congressional and executive power rather than on the grounds of partisan politics. National Constitution Center and C-SPAN friends, there's just one more day in this great experiment of public education. Tomorrow, please come back for day 6. It's going to be another blockbuster, 3 cases involving so-called faithless electors and whether states can force electors to vote for the people that they're elected to vote for president or not. There's homework, as always, for these discussions. You need to do it in order to be prepared, and that's to read the briefs. And several of you have asked, but you'll find them on the Supreme Court website, supremecourt.gov. And also, for extra credit, go to the National Constitution Center's Interactive Constitution and click on the Electoral College clause and also on the 12th Amendment and see essays by the leading liberal and conservative scholars in America with 1,000 words about what they agree the provision means and then separate statements about what they disagree. It is an inspiring model of exactly the kind of discussion that we've just been having today and all week and for the past 2 weeks. And I know that you'll learn as much from these essays as I do. With that, let me once again thank you so very sincerely, Andy Grewal and Gillian Metzger. Thank you for joining. Thank you, friends, and look forward to seeing everyone tomorrow. Bye.